Hello friends, in my YouTube channel Advocate Amit Kumar Gupta. Today I am going to discuss the case of BIMAL KESHAVLAL Patel versus Principal Commissioner of Income Tax. This case has been decided in 98 ITR Tribunal, short notes at page number 19. The matter has been decided by Ahmedabad ITAT and the date of the judgment is 5th August 2022. In this case, a very important aspect about section 263 proceedings, which says about revision by Principal Commissioner of Income Tax in case of when the order has been passed prejudicial to the interest to the revenue and it is erroneous. In this case, a very important aspect of section 263 proceedings has been brought on record. In this case, it has been decided by the Ahmedabad ITAT that in case Commissioner want to initiate proceedings under section 263, then it is the binding force of the law that the Commissioner of Income Tax has to tell in the notice that how the order of the assessing officer is erroneous and how it is prejudicial to the interest to the revenue. The facts of the case are very interesting. The assessee purchased a joint property in the name of two persons, assessee and second person is A. The consideration was paid by the second co-owner. All the consideration was paid by the second co-owner, that is A, and no amount was paid by the assessee. The circle rate of the property was 96 lakh. When the section 148 notice was issued to the assessee for the escapement of the income because the whole amount was paid by A, which was co-owner with the assessee and not by the assessee. And when the assessment proceedings were going on under section 147, 148, the assessee said that the whole consideration was paid by A, the co-owner, and not by the assessee. Assessing officer was satisfied with the version of the assessee because the assessee also submitted the bank statements of A and the bank statement of the assessee, because in the bank statement of the assessee no amount was there which was being paid for the purchase of the property. The assessing officer passed the order. When Commissioner of Income Tax was reviewing this order, he found that the circle rate of the property was 96 lakh. So he issued the notice to the assessee saying that the applicability of section 56 subsection 2 clause 7b is there, but when 263 notice was issued, there was no mention in the notice that how the order is prejudicial to the interest to the revenue and how the order of the assessing officer was erroneous. In response to the notice under section 263, the assessee said that when this property was purchased in the joint ownership with A, after that, due to some other factors, this sale deed was cancelled and the amount was returned by the seller to the co-owner A. The Commissioner of Income Tax admitted that your point is accepted but it needs further elaboration. And when the order under section 263 was passed, the addition was made. The assessee was before the ITAT against this order. The ITAT said that there was enough record on the file that the sale deed was cancelled, on the basis of which the 263 was done, and there was no mention in the revision notice that how the order is erroneous and it is prejudicial to the interest to the revenue. And in the order also, or in the proceedings also, the Commissioner of Income Tax has admitted that the point of the assessee is accepted but it needs further elaboration. So Reviewing all the matter and all the facts and circumstances of the case, it is clear that it was not a fit case for 263 proceedings, because the main point of 263 proceedings is that in proceedings it should be delivered to the assessee, it should be mentioned to the assessee, it should be pointed out to the assessee that how the order passed by the assessing officer is erroneous and prejudicial to the interest to the revenue. So the ITAT gave relief to the assessee in section 263 proceedings. At the end of this video, once again I am repeating the name of the case. The name of the case is BIMAL KESHAVLAL Patel versus Commissioner of Income Tax. Thank you friends.